From the counting of the simple mathematics, we are remaining with 5 weeks and 4 days. We don't count weekends. Okay, 5 weeks and 4 days for orals. Okay, so don't seize the fire, don't give up. I'll keep on reminding you that in orals, it's the only opportunity you have to shine. Okay, so let us make it a point that we are going to shine. So this is a week of family practice, which is known as the family relations. It is a week where we are dealing with succession, which we state that is a continuation of the right to maintenance. Because when you studied children, a child has a right to be maintained. And we said that the right to maintenance does not cease whatsoever. Okay? At any stage, whether you're dead or alive, your estate will always be subject to maintenance. And the question we always ask ourselves, who is subject to maintenance? This does not only move around your children, but it moves it around what we call dependent relatives. Okay? So the question for determination would be, who is a dependent relative, which we answered in our previous workshop. Then we also answered the question of who can apply for the grants. Okay, so as you noted that we have 2 types of grants, that is letters of administration and then probate. You'll come to realize that in circumstances where the deceased leaves behind a valid will, you underline the word valid will, we apply for probate. And in such circumstances, when we are applying for probate, the Administrator General has no duty whatsoever. Reason, all the duties and obligations that would be done by the Administrator General are already executed in the will. Reason, this will takes effect upon death. Those are one of the characteristics of a valid will, because we said it is ambulatory in nature. Okay, so that being the case, where we have a will, we go for probate, and that has been your workshop 1. So the presumption is at this point you are able to appreciate what validates a will and what invalidates a will. Okay, so the catchword in applying for probate is basically a valid will. So where we don't have a valid will, we don't go for probate. So when you look at your workshop 2, it deals with circumstances where we don't have a will or where we don't have a valid will. So what you should appreciate on workshop 2, that it deals with what we call letters of administration. So the presumption is at the end of this week, or this workshop 2, that is Wednesday, you are expected to be able to appreciate under what circumstances do we go for letters of administration. Okay, because you may think that we go for letters of administration only where the person dies intestate. Okay, that is not the case. So you should be able to understand under what circumstances will someone be presumed to have died intestate. Okay, you may go in orals, they ask you the different circumstances under which one is presumed to have died intestate. And you say, where one dies without a will? You ask yourself, that's what you say. Can I have done? Yes. Are you sure? Yes. Okay, not knowing that you have a number of options. Okay, so by the end of this week, we should be able to tell, okay, that if I'm given facts, okay, under this, we shall go for letters of administration. When you look at the first paper of 2019-2020, they brought facts and colleagues did caveat, but you couldn't caveat letters that had not been applied for. So there was a condition on a will, okay? And these guys had not yet applied for letters. So I had a colleague who did went for caveat. What are you caveating, sir? Okay? The process has not yet commenced. These guys are before you. They are telling you they have a contention with the will. So where the will is in contention, we go for letters of administration annexed with a will. So what you should note, because once a will is in contention, the presumption is it is no longer a valid will. So why do you proceed with letters of administration? Okay, so under such circumstances, you should be able to tell, okay, under what circumstances we go for letters of administration. In our previous session, we read what amounts to intestate, okay, intestate succession. However, we have other provisions that I want us to look at, okay, when we will be able to tell what we call other circumstances when we deal with letters of administration. Have you ever heard of what we call exceptional grants? Did you come across it when you're reading the act? We have what we call exceptional grants. Okay, under such circumstances, it would have been a grant of probate. But the reason why it's called exceptional grant, because the circumstances may provide for grant of probate, but you don't go for the same. Okay, you get it? Okay, so let's first get our succession act. We look at those provisions, then we come to our workshop. Okay, but the workshop is very simple. Okay, did you guys take time and read section 27 as amended? Yes? Yes, I did it. Should be able to tell what percentage, these women are funny. That act was enacted because of them. Okay? Okay, let's read section 225. Okay? It says grants with exception. Grants with section 225. Okay? It says grants, okay, with exceptions. So let's listen and say, it says probate etc subject to exception. Whenever the nature of the case requires that an exception be made, probate of a will or letters of administration with the will annexed shall be granted subject to that exception. You get it? Okay? It is a grant, but if the circumstances warrant that the grant should be made letters of administration, because there is an exception. So those exceptions are the ones we want to understand. Okay, because they are very clear. It says, whenever the nature of the case requires that an exception be made, probate of a will, okay? There is a will which warrants grant of probate, okay? Or letters of administration with the will annexed. So you get it? So it is an exception. The general is where there is a will for grant of probate. Okay, where there is no will, we go for So what is the exception to that rule? That's what I refer to here. We have a will, we would have gone for grant of probate. But the case before us has exceptions, which are making us to go for letters of administration, but not. So we are going against the general rule. So ask yourself, what are those exceptions? Okay, you have a will, but you say, we are going for letters of administration. So what are those exceptional circumstances? Okay. When you read section 226, it says that administration with exception. Whenever the nature of a case requires that an exception be made, letters of administration shall be granted subject to that exception. So, in your first workshop, we looked at contents of a valid will. Okay? So, if you know how to draft a will, as it was in your workshop 1 part A, whenever the will is not complying with what we read in the law, construction of the will, okay, just know we are going for those are what we call exceptional circumstances. So when you go to orals, they may ask you, counsel, under what circumstances can you apply for letters of administration? Don't say in exceptional circumstances. That means you are doomed. You've given all the circumstances in one. Okay, because then always they ask for 7 or above. At least if you can make a 6, that would be a better position. So now, what are the exceptions? Okay, so the first exception we have where the will does not mention and execute. Where the will doesn't mention and execute. So what is its purpose literally? Okay, what is its purpose literally? If to be honest, okay, we know very well that a will has to mention as executor, and the will has not mentioned an executor. Are we going to just close our eyes and give an executor? Okay, so that means we shall first go back to the administrator for clarification so that we get a certificate of no objection. Okay, then another one where the will is in quotation. Okay, the will may be valid. Okay, it has all the elements, but it is in quotation. How? He's saying that is not my balance. I'm great. She's saying, Mzee made that will. I was the one keeping it. Unfortunately, Mzee can't come back to testify that it's my will. Okay? But what she's saying is no. That is will. Because it is bequeathing the plot around one decade to her. And he's saying, I remember Dad was saying that plot was mine. So that will has a problem. So you see, they are saying no, that will is in contention. So where the will is in contention, you go for letters of administration annexed with the will. So you should be able to tell under what circumstances that the will be in contention. You see the practice, you see things in hand, you say, have you ever seen a will which is dead, but the alterations in a pen? Yes, it is typed, but then they cross out something, they write up in a pen. So such alterations, it is a very big character to bring a will to be in contention. Okay? Second, they can give you facts where I'm saying was listed, but the will is in English. Okay? Some kids are saying we've never seen dad signing. He was using a term, but when dad made a will in English with a signature. They have the document which has a thumbprint. Driving permit has a thumbprint. Voter's card has a thumbprint, but the will has a signature. You see, so you should be able to tell under what circumstances can a will be in contention. Okay. Again, look at the time when a will was. Mamamto is the one here, but Mamamto has been given almost 90% of the property. Mamamto has just been brought home. This will, okay, the heir is the youngest at home because it's from Mamamto. Mamamto. Eh? This stepmom of ours, what did she do to our dad? You see, so there will be a contention that our dad was at the extreme deathbed, couldn't write, but the guy has in his fine handwriting. Okay, that's yourself. Okay, you get it. Then what else? Okay, what factors invalidate a will? What other factors? Did you look at them? What other factors? Yes.
Insanity.
That one is a case basis. We have circumstances where they will give you where one of the witnesses was bequeathed property in the will. So you should read the law. Because sometimes a bequest to a witness does not invalidate, but we have circumstances where it also invalidates the will. Okay? When my grandfather passed on, brought us a will. We didn't have issues. First Muslims don't have problems. But it mentioned certain things. So now, after some time, one of our relatives came and said, Dad gave me that note. And she had it. We asked her how that we wrote. She came with the written document. Now, and all the women were like, Netta, Haji has never told us about that. It is a prime plot in Perere along the road. Even it has some rentals. Now she's telling us that Dad told me I'll be paying school fees for one of our siblings until she gets done. So in the exchange of that, he gave me this plot, and the written consent is here. So remember, this written consent can amount to codicil. So it was literally altering the will we had. But to make matters worse, one of the custodians of the will was the custodian of some of the titles of our late grandfather. But imagine, without consent of the entire family, this custodian gave this title to this lady. After the death, because that matter arose after some time when our grandfathers passed on. So, on inspecting, the title had been subdivided. Now we are asking, when did Mzee sign transfer form and invitation form? But the title had already been, but this written consent she had amounted to a codicil somehow. So remember, a codicil also changes the content. So you should put, so that means they can give you two documents. They can give you a valid will, then they bring a purported codicil. When the children are saying, no, this will is our father's handwriting, but this codicil, no, can't be our father's handwriting. But when you look at the law, it's very clear. A codicil also is a will. So what does that mean? The entire will be in contention. No one will accept that. So under such circumstances, we shall also go for letters of administration annexed with a will. Okay? If not that, we shall have a will, but when the will is invalid. So look at the factors that invalidate the will. Okay? So one, when it is not attested by the testator. So they'll give you a will. Yes, the handwriting of the testator. Now the children are they are okay with the handwriting, but when it is not signed, that means that will is not a valid will. Okay? If not, they'll give you a will which is witnessed by one person. And that one person was bequeathed property in the will. So that will invalidate the will and also invalidate the bequeath that was granted. Okay? But those things happen. Practice. Just look at the Administrator General's office. You will understand that when it comes to such games, people are there. Okay? If not that, they'll give you a will. Okay? When it has not mentioned all the properties. Okay? All beneficiaries. Okay? So when some of the things that are supposed to be
like the opening paragraph, sorry, I am so and so, the don't so and so.
That introductory part.
What if I don't want my name there, but I do what I want to do?
But what will show that it's yours? Okay? The signature sometimes is not sufficient. It's not sufficient. So it will leave a question around that, the validity still. So it will be a question of fact. Okay? Yes, answer. You want to make a will? Her last testament before Oros. Yes, guys.
I did not grasp well the scripture that I read about a will that has not named entirely the property. That they take that part that has been named in the will as that of a tested.
Yes.
Then the other one is considered as
but remember, it's an exception. Just as that exception in it. Okay? There is a will, but you have an exception. Okay? Which is warranting us to go for letters instead of. So whenever you see that exception, regardless of the existence of a will, so under such circumstances, remember, whenever you're a lawyer, what is required of you? To think very fast for a remedy that is appropriate. They have a will. Their father mentioned some property and did not mention some other property. So the presumption is he died intestate. For that is in the will and died intestate. So I go to make 2 applications. Okay, I go to make 2 applications. You get it? You're going to go for probate. After that entire process, then you come back to that Administrator General. You see how it's going to be hectic and very costly. So what will be the appropriate treatment? Attach the will, and the court will consider that. Then also, then go for letters of administration annexed with a will. Okay. So you just think, because the section is very clear. Exceptions warranting grant of probate annexed with a will. So the only application you have, think of the exceptions that will invalidate that will you make. So when you get in Oros and they ask you, counsel, give us 10 circumstances under which to apply for letters of administration. Okay? Just states where the will is in contention, okay, where they made a will in respect of certain property and didn't make a will in respect of some other property, where the will doesn't mention all beneficiaries, where, okay, actually, we need to say that issue that where the will is in contention, you can also, the circumstances that makes the will to be in contention, make them independent answers so that you can make the 10. Okay? The circumstances that can put a will in contention, maybe handwriting, not being signed, because the section is clear where there is no valid. So you think of all the circumstances where the will is invalid, so that each circumstance becomes an independent answer. Just once you say that, you've given almost 5. And you know, in orals, how funny things are. When you start speaking, that's when you realize that you don't know. Okay? You know, when they ask you the question in family that Rashid, give us the first question, how old are you? I don't know. You're mature. Now, cancel. With the provisions of the law, give me 5 legal importances of sex. On hearing the question, I thought I could attempt it. But once I started submitting like this, I had only 2 answers. 2. One was consummation. That one has a provision in the law. Okay? They wanted with the provision of the law. Then I thought of divorce. But the convincing the divorce part, I had to go for adultery. Okay? They had to explain adultery. Then I had those 2. Cancel the 3rd one. I started pausing. But on the face of it, you may say, Coca-Cola, but you start speaking. That's when I realized that, okay, I'm in hot soup. Already question 1 had hammered me. They told me to draft a caveat for letters of administration. All right. Hey, So the first one I drafted a caveat for land of it, because that one I needed to pay. So instead of going blank, I said, I get it, come away. So she looked at me like, okay. Where have you been? Because it was after COVID. I said, at home. Okay. Me, I can tell. Next question. Now, me, I knew question 1 and B. Question 2, I had only 2. I said, so I had to change the grounds of divorce. Okay? In 2 answers, so that I get at least the 3rd one. I went for desertion and adultery. Because desertion, even denying someone sex, okay? Then I also had to use the 3rd ground of divorce, which is worry. Also in line of sex, so that I get the 4 points. But after, because they laughed, but when they laughing, time was counting. They forgot to look at the timer. So I had now the 50 points. Yeah. Even me, what I said, I wasn't sure. She told me, you can justify your position. I was like, now, won't I die in my mood? Because I had to justify the position. The answer I gave lastly, that it is a ground that court bases on when they are making a decree absolute in sharing property after divorce. She told me, counsel, under which provision of the law? How does sex contribute to that? I started saying, now we see counsel in the different forms of contribution. We have financial, intimacy, and how counsel proceed. So I had to go with the intimacy part. Now how counsel proceed? That to explain. Now the doctor said, why? On the face of it, I saw that I could attempt, but after starting answering the question like this, so that's what I've been telling, that when they ask you the different circumstances under which you can go for letters of administration, we may sit as you can, but start. Well, you'll say one, where there is no will. Two, where there is no valid will. Okay? Why would you say where there is no valid will? How many circumstances that invalidate a will? All those are independent answers. So you say when the will is not attested to, when the will is witnessed by one person, when the will is not witnessed, all those are different circumstances. But once you say that when the will is invalid, so that's when you realize that, oh, I made a mistake. So that's how orals can hit you. Okay? So when you didn't cut, because they can't tell you in workshop 2. Because you see that workshop 2 says understanding the regarding letters of administration. They're not going to tell you that read the different circumstances under which you can apply for letters of administration. So for you, just read the workshop the way it is and let go. But the learning outcomes are clear. Appreciating the law regarding letters of administration. So before you say that you're done with workshop 2, if a question comes when they have listed provision things that go under section 225 and 226, what we call exceptional grants, can you really tell that this is letters of administration annexed in the way? Okay, so regardless, so you should be able to tell those are what we call the exceptional circumstances. So whenever facts come and you see that exceptional circumstance, there is a will, but in this will, someone mentioned the property and some property was left out. That means that is an exception to the general rule. Okay, now I've said you have 2 general rules. That where there is a will, we go for probate. Where there is no will, we go for. So these exceptions, they are exceptions on both sides. There is a will, but you're not going for probate. We shall go for letters of administration annexed with the will. So those are what we call exceptional grants. So don't take the general rule, because the workshop is only on the general rule. So it is your obligation to sit and think of the exceptional circumstances as well, because chances are high they will give you the IA when it is on the exceptional circumstances. Why? They have not talked about them in the IA. That's how you tell that, okay, this is what is likely to appear. So look at it and then go that side. So when you are drafting your documents, make sure you have a petition for letters of administration annexed with the will. Don't go for the general petition. Make sure you have 3 petitions. You have a petition for probate, you have a petition for plain letters of administration, you have a petition for letters of administration annexed with the will. Trust me, that's all about bad. Okay? But imagine you are in that IA. You know the way you sit in that line. None of you on that line has a petition for letters of administration annexed with the will. Imagine. It's how it feels like. Okay? It just has that one paragraph that changes everything. Instead of saying that, you have to include that the deceased died, tested, attached is a copy of the will. That the will has this and this. You show that yes, the will is there, but it has that exception you're talking about. Okay, and up here you don't say letters of administration, you say letters of administration annexed with a will. You show the petition that you are petitioning for this exact. Okay, so that you will be able to tell you are under what circumstances. Okay, so now we are going to stretch further than the workshop. because the workshop is too narrow. Okay, it's too narrow. Okay, so now we presume, because when we go to the workshop, it will take us like 5 minutes when we are done, because we have everything. Okay, so now we presume that you have petitioned for letters of administration, which law allows caveating grant of letters of administration, and who can caveat? Okay, who can caveat? Okay, so I'm doing this in favor of council for the week. Okay, to prepare in advance. Who can caveat? Okay, what grounds do you prove that you're going to caveat? That's what I understand. You've ever caveated letters of administration? Which law allows you to caveat letters of administration? Yes. Which law allows you to caveat?
Succession Act 7.
Yes.
I think under, is it still under section 253? Advocate Rashid.
Yes.
Section 253.
So who can caveat? Okay. When you look at section 253, says caveats against grant of probate or administration. So this means that you can caveat probate or letters of administration. So during our year, the person I was sitting next to, they gave us a question when the will was in contention, because there were alterations in the will. They crossed and wrote up. And remember, when you cross and you write up, you sign besides the crossings. So some of the children are saying that no, the words that we have crossed, the written handwriting is not for our father. Others were saying no. So now my colleague saw that contention and went for caveat. I told her, counsel, have they applied for letters of administration yet? Oh. So whenever you're dealing with anything, first ask yourself, at what stage? So ask yourself, at what stage do we go for? Do we caveat? Okay? At what stage do we caveat letters of administration or grant of probate? Okay? Okay. My apologies. Okay. So let's proceed. So as I was saying that when you look at when the question comes, the moment you make a mistake and you don't appreciate what remedy applies where, you're going to answer wrongly. So when you read a question, before applying for letters of administration, a caveat doesn't apply. Okay? That means they are either asking you, can they go for letters of administration plain? Can they go for probate? Or they're going for letters of administration annexed with a will. Okay? But where they give you facts and this person has applied for letters, so your obligation, if you have the grounds that are mentioned here in, okay, run and caveat. What are you caveating? You are caveating the process so that the process does not proceed. Okay, so this person must have started the process. Okay, yes. So when the question comes, ask yourself if it is coming from letters from succession. Succession, remember, is a process. It has steps. At each and every step, you have a different remedy. It has 3 steps. The first step is application. So when a question comes before the application, that means you are advising them to go for letters of administration or probate, whatever the case may be. If it is passed, when this person has applied, but it has not yet been granted, the remedy you have at that point is caveating. Okay? If it is passed when it has been granted, okay, can you caveat? You can't. So because it is already out. So the remedy you have is revocation and annulment. You get it? So that succession, it has 3 steps. So it's when you read the question and you understand that it's at this particular stage, you'll be able to tell that, okay, this is the remedy. But once you fail that, trust me, you look at the question and tell me, I'm over there for what? Okay? You get confused instead of, you've seen that the grant is already out, but the person who has the grant is the wrong person. It's not a member of our family. So how does that apply? This person needs up to these letters granted. So you say, let us revoke these letters. Okay? Let us nullify or let us amend. So depending. Okay? So that's how you should. So whenever the question comes, first put the things in consideration. Okay? So by the end of the time when you're reading the question, life becomes very simple. But the hardest thing at the back course is interpreting the question. Nothing hurts than writing a wrong answer. You get out of that auditorium, you hear colleagues speaking in tongues, and you don't want even to speak. I'm telling you, it hurts. You saw what happened in land. Everyone had a different answer. Okay, you failed. You say, okay. They are talking about cancer. And the process. What is the process? Deep inside you, why you messed with interpretation. So whenever you are interpreting these questions, take your time. Take your time. Always look for that art of simplifying things. All this will be very few. Okay? So now let's look at the circumstances under which one may caveat. Okay? So Our section 253 says, caveats against grant of probate or administration may be lodged with the High Court or a district delegate, and immediately, or any caveat being lodged with any district delegate, he or she shall send a copy to the High Court. Okay, so who amongst the district delegates? Okay, so remember, the general rule is a caveat is lodged where? High Court. Have you seen it? Even if you lodge the magistrate's court, it will be sent to the High Court. So now, cancel for a week. Look at the caveat that was lodged. Mpola, okay? Then the question is, okay? Yes?
That's what you just said. Does it mean that much as
What that means, okay? What that means that remember, once you know the subject, the matter stands into a contentious matter. Okay? Initially, before you know the caveat, it's not a contentious matter. Okay, so that's why they first notify the High Court, because the section is here, they send a copy to the High Court, so the High Court will give the directions of how to do it. Because once you lodge a caveat, it can't be vacated unless you lodge a main suit. Okay, that's why counsel for the week is proceeding by way of a plaintiff. Okay, because you have a right to succession, this right has been violated by the defendant by lodging the caveat. Your grounds are that the caveat has been lodged and justified. This person has no valid reason whatsoever. Okay, so now you come, when you look at this provision, has it provided the grounds upon which one can caveat? Okay, so what grounds do we base on to caveat? Council Gibbs. Yes?
Yes, Council.
Okay.
How do you mean that question again, Council?
What are the grounds, okay, that court bases on to accept your caveat? Okay. What grounds do you state in your caveat?
The first ground I would state is that depending on what is in quotation, one could be that I want to be a co-administrator and beneficiary.
That what?
That I want to be a co-administrator and the beneficiary to the estate.
Huh?
I don't know if that is a legal word, but
now,
can be.
One, the first ground you prove that you have an interest in the estate. That you have an interest in the estate. Yes. Whether legal or equitable, whatever the case may be. Okay? That you have an interest in the estate. Okay? Every time I look at this caveat and I remember what I got. I pass family. Me, I had issues with all rose. Okay. Was my first step after COVID. Okay. So another ground. Okay. So the second ground, any justifiable cause. Okay. Any justifiable cause. Now, there is a matter I had. It was with my colleagues, so I
Excuse
went.
me, Council.
Yes,
Kindly pardon me on the first ground.
the first ground is that you have an interest in the estate. Then the
Thank you.
second ground is any justifiable. So you sit and think what can justify. So it is a case-to-case basis. One, someone may apply when that person is not a beneficiary from the estate. We have brokers who apply for letters of administration. Yes. Okay. We have trustees who apply for letters of. Yes. We have mothers, not wives, mothers who apply for letters of administration. Mothers, just a mere mother. Okay?
Baby mama.
Baby mama. Okay? Now, okay, good example. If Zari dies right now, can Shakib apply for letters of administration? Why? But currently, everyone knows that he's dead. Okay? Okay, why? It's just, okay? But so if Shakib applies for letters of administration, have you ever had an application for letters of administration for the estate of the late someone? Why? Okay, he wasn't married. Do you think Sari doesn't want? But she accepted it because she knows once fire comes out like this, she can't pass the test. She can't. So what she did, she just decided to keep quiet. Let her manage the estate the way everything is. She doesn't want to wake up the devil. Okay, so she can't even pass the test to apply for letters of administration for that estate. And by the time Semanga passed on, the eldest son was how many years? Okay, the guy was 15. So they were also still kids. They could not apply for letters of administration. The parents of Semanga, they couldn't even temper with him because they couldn't manage the estate. Why? They had issues with domicile. You get it? That's why this estate is hard to administer. Okay? Domicile, remember, affects your application. 90% of his estate, movable and immovable, is in South Africa. Okay? So they could not, the only person who passed the test was the son, but the son was still young. So that's why the estate stayed like that. Okay? By the time, let me say, by the time subject man died, Sally was married. Customer to who? Diamond. Hey. And then they got married Islamically at Mombasa. So she had a lot of problems. So that's why the moment she could apply like this, people had justifiable reasons why they can caveat that application and say, let me drive the Porsche cars, I manage the schools and the hospitals, just like that. What enough, most of the hospitals and the schools were in the names of the children. That's how Shakib is enjoying. This world has no balance. Okay? So you see, so a justifiable cause is a case-to-case basis. May I have a case and so this family had gotten letters of administration. Okay? And from nowhere, I was going to New Vision, I saw that bank when they applied for letters of administration. Now they got some distant relative. Okay, because their intention was to defraud my client. So once I saw the advert like this, and they are marking, until now, nothing is taking place. What were they going to administer? The estates had already been distributed. What is the essence of administration? Okay, so you see, it is a case-to-case basis. So when the facts are given to you, ask yourself, do I have a reason? One, they always give you the first ground when this person has an interest, but the other justifiable reasons, they will always depend on the case-to-case basis. Okay, so now let's assume you have caveated. Okay, what is the effect of caveating letters of administration? Yes? It depends. Remember, the estate of the deceased is life. You can't update. Why? Because your debt continues, survives the debt, goes to the administration. So you can't update. Okay? So now, what is the effect of caveating? Okay, let's go to section 255. We've seen the format of the caveat. That's why I've jumped that section. The caveat is under section 254. Okay, that's the caveat. Okay, so 255 says that. So 255 shows the effect of caveating. Once a caveat is lodged, the effect is under 255. It says, no proceedings shall be taken.
Is that the amendment or the parent act?
Okay.
Rashid?
Yes, let's look at the amendment.
The amendment.
Yeah. Okay. It says, are we there? Are we there? Okay. 255 subsection 1, proceedings suspended if caveat is received. A person who lodges a caveat under section 253 shall within 14 days of lodging the caveat serve a copy to the petitioner for probate or letters of administration. Okay, so the first effect, it bars further proceedings. Okay, it bars further proceedings. It acts as an injunction to the proceedings. Okay, we go on. Then subsection 2, where a caveat is lodged in respect of a petition for probate or letters of administration, court shall suspend the proceedings in the matter until the caveat has been withdrawn, lapsed, or a suit for removal of a caveat has been filed and determined by court. So we only have these circumstances under which the caveat can be, okay, one, where it is removed by the caveat. Okay, you come to court, you remove the caveat peacefully. If that is not the case, you have what called caveat lapse. Caveat lapse. So ask yourself, what amounts to caveat lapse? Okay, what amounts to caveat lapse? Okay, what amounts to caveat lapse? Okay. Okay. Under what circumstances can a caveat lapse? Yes? Yes? Now,
When they continue.
yes, 6 months. Okay. Yes.
Shall we just section and interpret?
When the caveat does not bring any action 6 months after lodging the caveat.
Who follows the switch? The calculator or
The caveat should, and also the caveat and the other one is
is lapse above international suit. But how circumstance, when you read this law, okay, it's family simple. It's family simple. What's the effect of service? What if I don't serve? What is the effect?
Okay. Now, if the section says, okay, a person who lodges a caveat under section 253 shall, within 14 days of lodging the caveat, serve a copy of a caveat to the petitioner for probate or letters. So
It uses the word shall. What does that mean? It is mandatory. Say if I don't serve, it can be told you that.
you see, it is not something direct, but if you know how to read the law, you always get the answer. Okay, the section uses the word shall, so you don't have any excuse whatsoever. So you lodge or syndicate. Nange nkimanye nsirike ninde nakuzikuheyo kulaba nyasinga. Because you know in practice people play that games. Very. If around people hiding answers, okay, you've not seen bad people. Someone will have correct work in the book when the group did wrong work, and this person keep quiet. When they choose him to discuss, the guy will come with the book. And so when now they're projecting something wrong, this guy is saying something is exactly needed. Now the people will ask, who are the members of this group? Okay, leave around that work and they, but practice is something different. Okay, those are some of the behaviors we copy from here and bring in practice, but that will never make you succeed. Okay, so now, so once you file, the law requires that you must serve. We know the effect of failure to serve. So if you don't serve me with the petition, how am I going to get to know? Okay, and I file a complaint. So that means failure to serve is the ground you may argue to lapse that caveat. Okay? Are we together? Now, if not that mode of lapsing, it can also still be lapsed by court. How? That's now after you have filed a claim, a suit. Okay? So now, it says, okay, where a caveat is lodged in respect of a petition for probate or letters of administration, court shall suspend the proceedings in the matter until the caveat has been withdrawn, lapsed, or a suit for removal of a caveat has been filed and determined by court. So now, you first underline, okay, the word suit. Okay, underline the word suit. I'm trying to explain why counsel for the week is proceeding by way of a plaint. Okay. Now, after the suit, you go to what we call the Civil Procedure Act. That's the definition of a suit. Okay. So in your free time, go to section 2 of the Civil Procedure Act. Define the suit. Once you read the suit, it's not sent to section 19. Okay. When you go to 19, it talks about a plaint. Then after we go to order 4 and order 7. That's why we're going to be using a plaint. Okay? Are we together? That is for counsel for the week. Now, you've seen the facts. Okay? The presumption is you've loaded the caveat. Once you load the caveat, you serve and keep quiet. Your duty is done. So now it is the duty of the other party to come and disprove that this caveat has been lodged wrong. How? By disputing a suit.
Okay. So ask yourself, within what time do we execute a suit? So the limitation is different here from the original civil procedure rules. Okay. So let's go to section 255 capital A. It says a petitioner for probate or letters of administration in respect of which a caveat has been lodged shall, within 6 months from the date of the caveat was lodged, file a suit for removal of. So now what happens when 6 months have expired? You get it? Okay. So before you say you're going to file a suit, first ask yourself, are you still within time to file the suit or not? Okay, you get it. So you see, LDC, everything is very simple, but something small like this. Okay, you may be comfortable with it, and when you count the time, okay, because who are the plaintiffs? When you count the time, when you are out of time, you file a suit, the defendants raise a criminal objection that the suit is bad by law. Trust yourself. How is it bad by law? Not knowing that the section is clear within 6. Okay, if not, it may be the IA. And then you are out of time. Hey. And you ask yourself, how do I survive? Okay, so read the law, comfortably, don't panic. The answers are in the app, whether you like it or not. Okay, so as you are having such a question, the caveat has been removed. So ask yourself, whom am I representing? Am I representing the caveator or the petitioner? So if you are representing the petitioner, you have to file a suit. If you are representing the caveator, you have to protect the interest of the caveator. You get it? So that's how you see, once you realize the stage where the matter is, there is no question can fail. I assure you. Okay, so now the presumption is, okay, the caveat has been lodged and a suit has been filed. Okay, so now let's read subsection 2. It says, notwithstanding subsection 1, a person who lodges the caveat in respect of probate or letters of administration shall, within 6 months from the date of the caveat has been lodged, commence proceedings to prove the objections contained therein. So you see the difference. If you, that's what I told you. If you are representing, okay, the caveator or the petitioner, first count, have the 6 months expired or they have not yet. So within that, consider saying that, okay, within 6 months from the date the caveat has been lodged, commence proceedings to prove. So if within the 6 months, okay, this person, the petitioner has not lodged, has not filed a suit to challenge your caveat, you file your suit, okay, against the petitioner. For what? To prove the unjust arguments this person has been using to obtain letters of administration. So it is a two-way. So before you run for the facts, ask yourself, I'm representing. Okay, I'm representing who? But the challenge is, you see, the subsection 2 doesn't provide for how do you prove those grounds. Is it also by way of a petition, by way of a plea? Let's see. Yes. Okay. Okay. So when you read the section says, once you load the caveat, we get two parties. We get the caveator and the petitioner. A petitioner is someone who petitioned for letters of administration. Now his application has been caveated. So the question is, at that point, after lodging the caveat, within 6 months, so that means once the 6 months expire, you are out of time. So if the 6 months expire and you the caveat and you need to commence proceedings to prove your ground, the caveat will also lapse. You get it? Okay? Then, if the question comes, okay, when you are the petitioner, within after seeing that this person has lodged a caveat, file a suit to challenge. So those are the two. So when a question comes, ask yourself, I'm representing who? That is key. Once you go for a wrong path, I assure you will never heal. You can't heal from that saga. I'm telling you. Hey, you ask your predecessors. Their last eye at LDC, they have never healed from that eye of corporate and commercial. The question wanted them to represent the data, they represented the creditor. But 90% failed that eye. Imagine the entire LDC, Kampala, Lira, and Bara. Why? Okay, failure too, because I had these guys arguing, okay, because they always make the entire follow-up of the entire term, the entire year when you're going for final exams. So when Council Mwebembezi was making the entire follow-up of corporate and commercial, he started with that idea. So these guys were pleading the entire session, please Council, help us. I said, but your answer is wrong. What can I do for you? Okay, why? They represented the wrong fact. So when you're reading a question, you may look at the question, whom you're representing the caveat. Instead, you file a suit against yourself. Okay, so that is key. Okay, yes, guys. Which case now? Instead of saying that the caveat be lapsed. Yes, why? This person doesn't know who he or she is representing. That is the challenge. Okay? That is the prayer for defense counsel. But the idea one day. Now imagine you are repeated. Can you forgive that person? And you say that LDC is bad. What have they told you guys? And someone makes that mistake. You are the judge in that mood. Can you forgive that person? I swear I also give you a zero. Peacefully. That is the law. And you say, oh, this is bad. So let's proceed. Okay? Yes?
In other words, you are saying that unlike the land, whereby if someone has caveated my land, I just sit, wait for the 60 days to lapse, and that's the end of it.
You can also apply to court by notes of motion for caveat lapse.
But this one here, I don't have to sit and wait.
The law says you should also take a step. It's very clear to that shall. You can petition. You can also caveat you yourself. Okay, and you repeat the entire process. Yes. Once you prove and that the petition is dismissed, you go back to the Administrator General. Okay? So we proceed. Let's go for subsection 3. It says, okay?
where a person who lodges a caveat or a petitioner for probate of or letters of administration does not comply with subsection 1 or 2, the caveat and the petition for probate or letters of administration shall lapse. So you see, if within 6 months you lodge the caveat, okay, and you don't follow up, your petition that will cover and then the caveat. And it's serious case. The same thing, if I know the caveat and you don't suit, okay, put in a suit, the same effect. So we are there. Okay, the law to succession currently is hard because it has caused the problems than how you think. Okay, should have been at land unit. I saw Mukade coming. Yeah. With a lot of people around her, I knew 90% of brokers. I knew that automatically these are brokers. You know how they can use that status in it? Because they know things concerning the president, things are done chap. And they can always have this the buyer there immediately. I saw this Mukana, I said now. These guys have made this Mukade over from where? And you pity her. But why? She's an administrator somewhere. And things are not moving on well. The land is very viable where she is, but may God forgive us. Yes, Council. What if there was no caveat lodged? The law doesn't apply. But once a caveat is lodged 6 months, if the 6 months expire, everything lapses. Like that. Okay? Yes. It depends on the determination of court. If court upholds the objection, the petition doesn't proceed, you go back. If court dismisses the objections, you proceed with the petition. So it depends on the ruling of court. Yes. Yes, guys. So within the 6 months, if for you also commence your suit, also this person, if this person doesn't take a step, you shouldn't keep quiet. You should also lodge a suit to prove your grounds. So if we also don't proceed, this person, the petitioner, has also instituted a suit to disprove your objections. If none of you takes a step, it lapses. Okay? That's how funny the law is. Okay? Then the last provision under that says, where, yes, section 255A, subsection 4. Where a caveat lodged under subsection 2 lapses, the person who lodged the caveat shall not lodge another caveat in respect of the same. You get it? You have one opportunity. So, if you lodge a caveat and it lapses, you did serve, okay? The 6 months expired, did nothing, or a suit was determined not in your favor, and the caveat was removed. The law says you can't lodge any other caveat until so it's available. Okay, you can't lodge any other caveat on those letters. That is proud country. Okay, that's proud. Okay, so you see, so now, if not, so the presumption is, okay, the caveat was lodged and it lapsed, and letters were granted. If not, no caveat was lodged and letters were granted.
Okay, so that means you can get facts in these three phases, how I'm explaining there. We saw the first one, then the second one is when the process has. So let's presume that the letters were granted, okay, and they are there. But let's assume you were out of the country by the time you come back. Letters on table. Aisha is saying, okay, she holds 4 phones walking around. Okay? This one is for a broker from Nasana. This one brokers from Wanegea, because the estate is in different places. So she baby, wait, no. Okay, why? She's the administrator. Okay, so you are really confused of how Aisha got letters of administration. What training do? So I know this what we are going to look at is not part of this workshop, but I can't come in here. I spend 1 hour. That's why I had to go through it. Okay, that will be corruption. Okay, when we are in school, we used to be happy if they say that the mathematics teacher is not coming, not knowing that that is a form of corruption. But after reading the law on corruption, I said, oh, all these teachers were corrupt, who used to leave books behind and copy notes for ourselves. And they later come. They say, where did we stop? That was corruption. So I can't be that corrupt teacher. Okay? So now we've passed that stage. Let us have been granted. So now we want to see what remedy is available in such circumstances. So we are going for what we call revocation, annulment, or so you should be able. Those remedies are different. We have what we call amendment of a grant. We have revocation. We have annulment. Okay? You should be able to distinguish. Facts will come when they don't call for revocation. Facts will come when they don't call for nullification. Okay? So the section is literally one, but my ear interpreting that is another different story. Okay? So, comrades online, are we together? So now, which law provides for revocation and annulment? Okay, so let's go to section 200. Okay, let's first look at section 265. It says procedure in contentious cases. We all know what amounts to contentious cases. Okay, these are matters that need proof and examination of. So remember, the general rule is family matters are not contentious. Okay, that's why you first go to the administrator general. All contentious matters you get out when they are sorted with a consent. That consent which is represented by a certificate of no objection. So in succession matters, the presumption is all matters are non-contentious. Everything is straightforward. A will is there. So what makes it you get it? It has mentioned this is my property, these are my children, these are disputed, and this is my executor. Is it in contention? No. Okay, but once it turns into a contentious matter, this section provides the remedy. Okay, if we come from the administrative office, we have a certificate of no objection that we have agreed that let Aisha be our solo administrator. It is no longer in contention, which must say, but there is a point where it can turn into. So once the matters turn into contentious matters, how do we deal with them? Okay, so this is the law we read first. Okay, it says procedure in contentious cases. In any case before the High Court in which there is a contention, the proceedings shall take as nearly as may be in the form of a regular suit according to the provisions of the law relating to civil procedure, in which the petitioner for probate or letters of administration, as the case may be, shall be the plaintiff, and the person who may have appeared to oppose the grant shall be the defendant. They are going to, you wait, you're playing. Law applicable. Okay? Law applicable. This section should not miss. Remember, it started as a non-contentious matter. So now, someone is coming, lodged a caveat. It has turned into a contentious matter. So what does this imply? This is the first section you're going to deal with. Okay? This is the law that allows you to go under the civil procedure rules and the act everywhere. Okay? Are we together? Yes? They also amended it. But is the amendment fatal? Okay.
The amendment puts that its number is okay as subsection, but delete all the ones that appear after.
Okay.
Then it added as subsection.
But it's okay. This was just an explanation. Okay. So now we presume that is okay. So that's why I first explained that the general rule is all matters in family are none. So now, once the matter turns into a contentious matter, you cite that law. Now, ask yourself, what is in contention? Okay. So now, in circumstances where the will is in contention, that's the things that will make you caveat. So that means once you caveat, it has turned into a contentious matter. So we are past that stage. Now the grant is out. We have it. There is no part, it has turned into contentious out. So let's go to the law relating to revocation, annulment. Okay. Was that section amended of revocation or not? Okay. Which law provides for it? Annulment, revocation, 250, 234. Was it amended? First confirm. It was amended. Okay. So those with amendments, look at 47. It says Section 234 of the Principal Act is amended in subsection 2 by inserting immediately after paragraph E the following: the person to whom the grant was made has mismanaged the estate. So let's first come back. We read the Principal Act. Okay. It says revocation or annulment. Okay. You get it? Revocation or annulment for a just cause. Okay. So you should underline the word revocation and then annulment. What do we revoke and what do we annul? That is the question. Let's have two circumstances. One, let me use this example. let's assume Kakaire is dating Aisha, okay? But she knows that Aisha doesn't like a particular type of people, okay? But Kakaile misrepresents himself right from the start as that right person, okay? As that right person. So Aisha falls for Kakaile Chukuri. But when the original Kakaile is somewhere hiding, like, okay, let us first go over. You understand me? Okay? So that means Kakaile fraudulently obtained Aisha's consent. Okay? You get it? So that means right from the start, consent was obtained fraudulently. Is that marriage void or voided? So you go, what do you go apply for? You get it? So now come here. We have nullification and then revocation. We revoke something, okay? And we nullify something. So now, a petition for nullity in actual sense happens in circumstances where any of the parties didn't have knowledge. Okay? Any of the parties, not where or even binaro that said okay? You get it? So once you realize the truth, you can go for nullity. But when you right from the start, money, okay? We are in prohibited degrees, but we want to get a visa to go to US. Let us get married. That marriage is ab initio wrong. Okay? So are you revoking or you're nullifying? Exactly. So when we are reading this section, where fraud was there right from the start, we revoke. Okay? Yes, where there was fraud right from the start, because we know one, when you apply for letters of administration, the following things should be there. Once they were not there right from the start, that grant should be revoked. The law doesn't sanction and okay, but where on the face of it, I also didn't know. Let's assume I thought because I'm a layman, but the jurisdictions, the estate falls within the jurisdiction of the high, but because the Batugamba go to the court, okay? So I came to LDC Magistrates Court without knowledge, okay? And I obtained a grant. On the face of it, the grant looks to be, but it has a problem. You can't revoke. You just go and nullify your property. You get it? Okay? Then we have what we call amendment of the grant. Okay? Amendment. Here, everything is okay. The grant is okay. But you feel like some changes should be made. For example, you had two administrators. You obtained the grant in a very right manner, but one of the administrators dies. And the law is where the grant is given to two people, one can't administer the estate in absentia of. So are you going to repeat the entire process? Just make an application, they amend. You put someone who is suitable. You go on. Okay.
I'm looking at a scenario where that may be signature fraud.
That is fraud. You revoke.
And you revoke. So how about the transaction that you have been making?
Everything is in nullity. Everything. It is void. All then in succession, Court has powers than how you think. They can reverse everything. If not, they proceed against the person state. Yes. Yes, guys. Mm. It is true. Now that means the will be in what? In contention. Okay? So you should be removed from children to dependents. Why? Section 27. The share of a defendant, the dependent, is different from a share of the children. So where got what percentage you have? Mama wa say say of okay, so you see it has turned out to be contentious. Yes, sir. Yes. They cannot. Where it is granted for more than one, you can't administer absentia of one. So the three should be available. Once one dies, replace there and there. It becomes an offense, intermeddling with the estate of the deceased. Okay. Yeah, we are going to see the law. Okay. Has there a question?
Now the taxation give families names, payers, and payers. Now you look at that pension. I look at that pension where I don't want to go to it. But under the Succession Act, we will say peasants. You understand? It has a right to benefit from that estate. So what we thinking there? Which one is first?
Now, a guardian, what effects of guardianship? They don't create blood. Yes. So you remain a dependent. So the question for determination will be, are you partially or wholly? Okay? Where you are partially, you will get that portion for a partial dependent. Where you are wholly, you will get that portion for a wholly dependent. So it depends. Okay? So now, let's proceed. Let's read. It says, section 234. So, it says you can revoke or annul for a just. So, what does this mean? The grounds upon which you revoke or annul are known as just. So, what amounts to just cause? Unlike in other civil matters where just cause is a case-to-case basis, here it is mentioned. Okay, so it says the grant of probate or letters of administration may be revoked or annulled for just cause. In this section, just cause means A. So when you are reading, just you should be able to tell that here there is a fraud, we nullify. Here there is no fraud, we go for. You get it? Here, revocation here. So it says that the proceedings to obtain the grant were defective in substance. Were defective in substance. What does that mean? That right from the start, everything you had was wrong. Okay? So, under that, you knew You knew deliberately, no Chikola. We shall go for what? We shall revoke. Yes?
This one can be defeated by 10. For example, in the law of limitation.
I myself have one I'm trying to challenge. The letters were obtained in 2009. But the estate, in the petition, the guy said the estimated value is 10 million. The petition was in the High Court. In his petition, he didn't list anything like the estate. The word goes on. But in actual sense, when I got to know the estate, 1 acres, I think the smallest estate had 30 acres. But we are just trying to challenge Karen. But the fool has sold. He sold the. I saw an argument where the guy sold. Okay, the 100 acres. Sit at 2 million each acre. Was it 2 million? Because I think he gave these guys 500,000 each beneficial, but they were young. So here we said is was a now I tell advantage of cancer, teenagers will talk for you.
But no, and those clients of this reverse that transaction.
That's why we calculated the entire estate. All the titles are not yet changed. So depending on how the transaction is, if the title had changed more than 3, you can't reverse. You will be stopped. You go for compensation. But here, some of the estate has not yet even been sold.
But then we'll
No, that very person, the administrator, you proceed against his personal property. Okay? So you proceed. Then B, that the grant was obtained fraudulently by making false suggestions or by concealing from court something material to the case. So you ask yourself, what is material in the petition for letters of administration and the petition for probate? Okay, then you will be given facts where a stepfather applied for letters and left out. You are concealing. Okay, you will be given facts where someone knowingly concealed some of the properties. That is concealing something important. Okay, so you should be able to tell what is material in these proceedings. Yes.
Where someone obtained his letter of administration.
Yes.
Maybe he has told God maybe that the disease will be left and let me say this point. I know someone is dealing with that estate in Masaka. When you are coming to buy this land in Masaka, you are dealing with this administrator, but then about administration. Because all of the letters of administration I've seen, they really show where he has power. Is he making the right transaction in Masaka yet? His letters are
now
all the sanctions.
That's why they say list the entire estate. Okay, list the entire. One of the duties of the administrator is to first search all the credits, okay, and debts and all assets of the deceased. So if you leave something out, you are in breach of your. You get it?
So if I want to deal with it lawfully,
I need to include it, whether it is in Masaka, whether it is in Juba, include all the assets of that person.
I didn't know that that's my father's estate.
Yes.
But now someone told me your father left the land in Boyma, but the time he was working.
Then you can apply, they amend the grant.
they include
Where
that.
I deal with it without putting it here,
It is an offense. You concealed that, they will take that you concealed it. Okay, so you deal with it lawfully. Okay, then C, that the grant was obtained by means of untrue allegations of the fact essential point of law or of law to justify the grant, though the allegation was made in ignorance. You get it? Here they're saying that the grant was obtained by means of untrue allegations of fact essential in point of law. What fact is that? Pecuniary jurisdictions. But that allegation was made, okay? Though the allegation was made in ignorance. That's what I've told you. What in our human? Okay? Mumateka, above this, go to the High Court. You get it? So it was made. So under that, did you obtain it fraudulently? Untrue. So you are innocent. Do you revoke or you nullify? You go for nullification. You see that the sections are about reading and saying that this. Okay? Then that the grant has become useless and inoperative through circumstances. Okay? It has become inoperative. Mujirina neterina makulu. Okay? It was obtained in a very true way. Okay? So do you revoke? You just go, you nullify. Never kuwa mwenda. Okay? Yes?
With the amendments, now we talk about 2 years of the grant. What is the effect of those grants that were granted from time to see someone who has a grant, which has just more than 5, 10 years? What is the effect? Does that become more paradigmatic?
Now, that one, if it was, because the inoperativeness in the amendment, where the grant is there, but the guy has just sat for 2 years, that means it is useless. Okay? But before the amendment, you couldn't take 2 years. It could be more than, because the law had not specified. Me, I have an estate I saw in Nakase, where I also bought some time back. Okay, I went with my father and we bought on that estate. But the guy had spent with the grant 20 years without doing anything. The guy works with the grant and all the titles. The guy obtained the grant when he's still a youth, but the guy is old. The relatives wanted to beat him at least. Okay, they forced him. They took him back to the Administrator General, and the estate was reverted back to the Administrator General. Nenga gaya alenye. Ngayagala bafe abana be bakitwale because it is a square mile. Just here in Nakase town. Hey, joke with relatives. Okay? Now okay. Then lastly, okay, that the person to whom the grant was made has willfully and without reasonable cause omitted to exhibit an inventory. Okay? Why? Why do you fail to give an inventory? You have some reason, some fraud behind that. Okay? I don't want to disclose now. I saw certain set of facts where someone filed an inventory in the petition. The guy said that he went for letters of administration, indicating that the deceased died intestate. But now, when the fool filed the inventory, he said property this and this was dealt with according to the will. You get it? You have letters of administration, but now the inventory says you distributed according to the will. So what does that mean? There is a will where what you That is the matter I'm dealing with. That's the matter I'm dealing with. I don't know. I'm waiting for him. I filed. I'm waiting for him to come. Agwe memo oba tule kumeza wa abana ebintu. Mutima mulungi. Yes. Yes.
Why are they administrator? That is contrary to the orders of the How is that?
It is disobeying your lawful orders. You proceed against that person under authority. Remember, administration applies to courts. He gets an order to administer. So he administers according to the orders of court. So once he gives that order, so it will be contempt of. Even if you have some people, what they do when they have an administrator with someone, they have make an application and the estate reverts back to the administrator general. Like that. Okay? Okay. So now, then when you look at the amendment, they gave another ground. Okay? They gave another ground upon which you can deal with that. Okay? It is that the person to whom the grant has made has mismanaged the estate. Otunzo mazewo, that is mismanagement. So now, once you are given power and you go for that order, can succession become hard? Okay, so that means, but literally this is going to be next time what we've seen. But this time you are stopping at caveat. So, any question before we go to do the workshop? Yes, thanks. That would be the best. Section 27 as amended. Why? It will confuse you. And you set section 5 of that. You get it? Because if they look at it in the amendment section 5 and you forget to set section 5 of the transition amendment. That's what you have. But if you set section 37 as amended, you can tell. You're going on, you get it. That is a bit like it, but it will confuse you the more. But you just set section 27 as amended. That's it, it's a bit better. Okay. Yes. Any other question? Aisha, yes. Yes. So now, should we go through the workshop? Okay. Let's go through the workshop. Okay. But remember, whatever is in the workshop, we cover it in workshop 1. Okay? Maybe the sections relating to duties of administrators, it is just a straightforward section in the act. Okay? Doesn't have miracles. Then duty, and maybe differentiate between duties and powers. Okay? Differentiate between duties of administrators, and powers. Those two things are different. A duty is mandatory. One, for example, you have a duty to file an inventory. You have a duty to collect all the debts of the deceased. Okay? You have a duty to collect all the estate. You have a duty to manage and distribute the estate. You have a duty to pay all the debts. You have a duty to arrange the final funeral of them. Those are duties. Then you don't even think of any option. In a duty, you don't have an option. But a power is discretionary. For example, you have the power to invest. So it is discretionary. You may or you may not. Okay? You have the power to sell. You may or you may not.
You get it? So when you are reading the act, draw that line. Okay? So let's get our facts. 10 minutes and I will call it a day, inshallah. The same thing. Powers of the Administrator General are in the Administrator General's Act. Again, when you are reading it, differentiate the power and a duty. That's the yardstick of determining which is which. A power and a duty. Okay? Duty what the answer. Okay? Then the power, discretionary. Okay, you may do it or you may not. You have the power to sleep or to wake up and do it. Okay? That is your power. You get it? Say why? Since say now. Okay? You can't. Okay? But when it comes to Friday, miss the IA. You have PC. Okay, so let's go on. So, workshop 2. Okay, it says that I am Santa Adrico. I am 23 years old. I am a student at Mbara University of Science and Technology. My father, Quinto, died in his sleep on the 23rd of November 2022. My mother, Evelyn Avao, who was my father's only known wife, underline only known, chances are high there are still others who are unknown. Only known wife, okay, died in 2019 of ovarian cancer. My sister and brother are Suzeto and Simon, age 21 and 27 respectively. Suzette is a student of medicine while Simon is in senior 5. At our father's burial, we learned that he had a daughter called Lillian Anzo, whose mother, Martha Motes, is a double-trained nurse working with Kaworo Hospital. Lillian is 4 years old. Our father fully maintained his sister's children, Simon Kagwa and Nelson Kagwa, aged 15 and 12 respectively, from 2017, when their mother, Rita, passed away. Our father did not know their father or any of their relatives. We do not know the Kagwa's family either. Our father left the following. So from the paragraphs we've read, what things are you supposed to look for? What nature of succession is this? Intestate. Okay? If it is intestate, okay, who are the beneficiaries from the estate? Okay? They have mentioned there. Okay? Which we know, can easily tell. Then after, they are giving you who can apply for letters. So, who has the first priority? But the wife died. Okay, the children. So who is this guy? Is 23. Is of majority. So he has the first priority. Okay. Yes.
This was that country they wanted to ask. You see the same capacity. They look at the minority and they look at the others.
Yes.
And one dies 8 days a week.
Make a will. Yeah.
8 years. Yes.
Can make a will.
And that money
You see, that is the issue. Listen. You can find the someone
Giving back.
okay.
It can still
But you can find someone who sits the way.
at 8 to 9.
You don't do. Well, I was thinking that
Cancel. Now, when you go, it depends. You see the things they determine, things that make one lose money. That man had an entry. One of the things that make a man extremely bright, being sexually active. You get it? Okay? And one of the things that keep women extremely active, not giving birth. May have my grandmother, she never gave birth. She's 89. But Omukaza, 80. But when you ask them, Sagama, since she didn't give birth, she's still purely active. Reason, giving birth stresses women, but it doesn't stress men. Okay, so now that guy was sober. So if your counsel from a defendant, unless you have a counsel is not sober as well. Okay, but look at the circumstances under which that deal was made. Circumstances one, Yanina Mucharat at the time of making that deal. Well, no, the answers are high. There was influence. We'll proceed. Okay. So yes. Now, counsel is asking. Okay. Let's come back. Okay. What was this thing amended? Yes. Okay. Members, listen. The small estate rules, were they amended? Were they amended?
yes.
Were they amended?
Yes.
Look at the amendment, Council. The special provisions were amended for priority. Initially, the priority was on children, but the amendment considered the spouse. Okay? So where the spouse is not available, the children will take the second position. So when you look at our facts, we have the children. So they will take on the second position. Okay? So now, then when it comes to the beneficiaries, the reason why they gave you Martha Mutes. Why? Martha Mutes is their stepmother, but who was not legally married. Is she a beneficiary? Yes. Look at section 27. The child is the one who. So now, if these kids run by me, you get it? Okay, so if you are not legally married, then benefit from your father's estate. Okay, so my good sisters, get married. Yeah. These men here are looking for potential women. Okay, yes, answer. Yes.
To write your petition.
Now the challenge is to have what we call principles of equity. So our laws, they are trying to embed equity by force. Because one, they are saying that so obudde bw'omalidde omukyalo olw'okuba ofudde aba babanega mugoba oba tolyayo mmere oba tosulayo. So by virtue of equity, this woman is supposed to get. Okay? So when you look, we have a lot of cases trying to change positions concerning women. Even we had a case from Mbarara High Court that a mere calm we stay together amounts to contribution. Why that was? So she could benefit from your
but the laws are still okay.
That one in the case.
We have a case, is it from Zimbabwe or Zambia, which says that the academic qualification obtained during marriage is matrimonial property.
Well, I'm having sleepless nights here.
So whoever is married here, this diploma, okay, you are obtaining here is matrimonial property. So whatever proceeds you're going to get as a result of this diploma, you share with them.
We'll be ready in the Supreme Court.
Okay. Okay. So, but women can cause problems in this world. See the way you're suffering in illness, and your husband comes, my dear, yeah. Okay. So let's go on. Okay. So now, let's go on. So we are not going to go through the escape. Okay, that one you can tell. Okay. Then, lastly says that I have reliably learned that Lillian's mother has engaged property brokers to find buyers for the house at Kauku and the commuter taxi. She would like to draw the money on the bank accounts with the deceased used to operate. When you look at that, it requires an immediate remedy. Which immediate remedy is that? To caveat. Okay? To caveat. Okay? Now we have a bank account. How do you deal with that? What do we lodge in a bank account? A garnish. That's how we caveat a bank account. Okay? Because if the process of getting letters of administration may delay, okay, and she has contacted brokers, okay, so act swiftly, okay, then you're not lodging a caveat for letters, you lodge a caveat to the title, land at Kauku, okay. Then for the bank, you just make an application for garnishee proceedings. Okay. Then tasks. Identify the property, that one is okay. What is the necessary procedure in order to lawfully manage the property? They want a procedure for obtaining letters of. Then additional information, that one you can. Then assume relevant information, draft, that one is a petition. Then D, explain the procedure of obtaining the grant, that one is okay. Then E, oh no, this workshop didn't deal with E. Supposing that Santa Adrico and Suzeto applied for letters of administration before the High Court Family Division, and the notice of their petition was published in Monta newspaper of that, they have confirmed that Martha Mutes lodged a caveat upon their application on that, upon the grounds that she is the widow of the deceased and such entitled in priority to the grant. How do we challenge a caveat? Yes, how do we challenge a caveat? You are the petitioners. How do we challenge a caveat? You're going to file a suit disproving, okay? Disproving. She's saying, okay? She's saying she is the widow. Who amongst your widow? So, in the facts they told you, the only known legally married died. That you know, okay? Then F, supposing that Quinto was a Zambian called Simon Chilima, and that he was the registered proprietor of land under leasehold tenure in various places in Uganda, and that altogether this land was worth 1 billion Uganda shillings. Assume further that he died in a traffic accident, okay, in Lilongwe in 2021, and the letters of administration in respect of the estate were obtained from the High Court of Zambia, vivid that and that. Advise the beneficiaries. What is that? Receding. But ask yourself, first can't read where that law applies. When you get to the probate receding rules, first read the applicability. You see whether Zambia falls within before you apply them.
No, but I think there's an amendment.
Yes. Okay. Initially, it should be East African. So now it was opened to Commonwealth. So again, also made the Commonwealth as well. Is Zambia part of Commonwealth? Then you apply. So don't just okay. Okay, so they provided for other. The part where you have reciprocal arrangement, Commonwealth, and then the entire East Africa. So you first ascertain one, is it under Commonwealth? If not Commonwealth, do they have a reciprocal clause? So you will apply the property receding where they don't apply. Okay, so whenever you give any country, first ascertain. That's why before you apply the law, read its applicability to the fullest. Okay, that's what happened in some cases. Council was dealing with a matter in the Supreme Court, and they applied the civil procedure rules. Okay, in a certain petition, they applied for leave to amend pleadings, and they cited the civil procedure. They applied the Supreme Court. So read applicability. Not all lawyers are wise, okay, but all lawyers are good. Okay, they don't apply. We have the Supreme Court rules, and even do they also apply the Court of Appeal? We have the Court of Appeal rules. Read the Civil Procedure Act, Section 1. They apply in the Magistrates Court and the High. So that means the Civil Procedure rules only apply to High Court and Magistrate Courts. Never apply them to the Court of Appeal, and we have the separate rules. Okay. Yes.
On the procedure of applying for probate and letters. Then
Yes. Letters of administration, they're different. You go for you notify the Administrator General about the death. Okay. Then after notifying, the Administrator General issues a notice calling for a meeting. Then they convene a meeting, and on consensus, they grant a certificate of no, which doesn't probate. Okay. After that, processes. Yes. So let me wish you the best of luck. God bless you. Grant you knowledge, wisdom, and understanding. Assalamu alaikum wa rahmatullahi wa barakatuh.
Which grant is this?
Okay. Letters of administration.
So it's a repetition of this.
Yes.
But do you
Whatever
apply
it's
them
so
or it's the same?
No, it's
Yes.
So they repeat this and this at the same time.
yeah. Here, okay. Remember they're talking about court here at the Administrator General's office.
Yeah.